given the discretion under the covenants to say what fits and what doesn't fit. And they can apply not just those objective criteria, but also the subjective criteria of what they find to be fitting within this community. So it is proper, and we are not going to interfere with their decision unless they do something improper. They don't follow their governing documents, they act arbitrarily or capriciously, they don't act in good faith, they're discriminatory, but otherwise we're going to uphold that decision. Now the interesting footnote to Ms. Dolan King is, does anybody know what Mr. Dolan King does for a living, besides Darren, who's out in the hallway?
Yes, I know.
What does Mr. Dolan King do?
He's a mafia type person.
Mr. Dolan King had made a lot of money, and the reason they needed this very strong fortress around their home is due to the fact that he was a fugitive from the FBI for 30 years. He actually had his fingerprints surgically altered because he was a cocaine king. And he is currently serving 5 life sentences in federal prison in New York because he was busted with that much cocaine at one time in his possession to serve 5 life sentences.
So he doesn't need that fence.
So he doesn't need the fence anymore. In fact, they have been, he's got a fence. He's got a really nice product fence now.
Should probably be electrified.
Yes. Well, and the funny thing is that the Dolan Kings have been to the appellate court 3 times. And now the association, of course, is spending its days trying to collect the attorney's fees from all of this litigation. So that's an association that did it right. Let's talk about an association that did it wrong. How many people have been to Monarch Beach? A lot of people. Okay, just been to the beach, period. We've all been to the beach. We've all been to golf courses. I've talked to these nice gentlemen about golfing. So imagine a community where we have both. We have a beautiful ocean view, we have a beautiful golf course view, and we want to protect those views. So in our CC&Rs, because we don't have view protection in California, it's not a statutory right, it's not a constitutional right, but it does come out of the CC&Rs. So in this particular community, they have a restriction that says no tree can grow higher than the roof line. So we can keep these views. Well, what happens to a palm tree when you take off the top of it and cut it to the roof line?
It does.
It becomes a stick, right? A big, huge stick. And the board president in this case, you need to know this little salient fact, the board president in this case has 18 palm trees on his property. And so he and the board decide, well, that rule is kind of silly. That rule in the CC&Rs that applies to palm trees is kind of silly. So why don't we just create a rule that says that applies to everything but palm trees, because logically it doesn't apply to palm trees. So they adopt that rule. The homeowners, who don't like the 18 palm trees that are obscuring their view, sue. And so the court comes along and says, you know what, that may be a logical view in your viewpoint, board of directors, but we can't apply this rule of judicial deference that we've given you in Dolan King to this case, because what have they done? They've taken the recorded covenant, the recorded CC&Rs, and they've tried to amend it. They have amended it, but who has that power to amend it? The owners. The board does not have the unilateral right to amend the CC&Rs unless your CC&Rs say that. Oftentimes the CC&Rs that we draft at our firm say the board has the unilateral right to amend the CC&Rs for non-discretionary items, such as the items that Darren was talking about, Open Meeting Act. You guys don't have a choice whether or not to comply with that law. That law exists whether or not it's in your governing documents. So why not allow you to amend your governing documents unilaterally to put that in there? In this case, they did not have that right to unilaterally amend their CC&Rs by creating a rule. So just remember, if you're creating a rule, if there's something in your CC&Rs or your bylaws that you don't like, you need to go out to the membership for a vote. You can't just remove it by creating a rule around it. Okay, so the application process is really important. If you have incomplete applications, that you deny them. Do not say approved with conditions. Approved with conditions make lawyers break out in hives, because we then have to prove what those conditions were. If you deny it, it's a cleaner case for us, right? It's just been denied. Similarly, how many people here have that language in your documents that says, if we do not get back to you in 30 days, your application is deemed approved? Oh, that's one of those sand traps at Inverness, right? You could just fall right into that one. So you don't want to blow that deadline. Darren's working on a case right now where there's an issue involved in the case with respect to whether or not this homeowner was approved in that 30 days or whether we denied him. And there's something like, how many hours are involved in that? Maybe 24, 48 hours. it's a very short time frame, and they're litigating about this, whether or not it was denied in the appropriate time frame. So make it easy on yourself, make it easy on your manager, make it easy on us, and make sure that you're aware of those deemed approved language. So let's move on to another board. Clear Lake versus Cramer, Riviera versus Cramer. How many people here have been to Clear Lake? Pretty cool community, right? So the community, from the pictures that I've seen, and you can tell me those who have been there, it kind of slopes down to the lake, right? So imagine the lots, they're kind of sloping down. And in this association, they have a restriction that says you cannot build a house that is higher than 17 feet above the control point of the lot. The control point of the lot is the middle of the lot. So that's where you measure the 17-foot height restriction. Again, it's a view protection, right? So that everybody has an equal view of the lake. Along comes Mr. and Mrs. Cramer. Owner-builder applies to have a house on their lot. The association says, Mr. and Mrs. Cramer, sign right here that you understand the 17-foot height restriction. Mr. and Mrs. Cramer sign. Mr. Cramer, why don't you draw a picture right here and sign it and say that you understand? Mr. Cramer does that too. His application is beautiful. It is stamped. They have bait stamped the pages, so we know that he can't slip sheet, meaning put in things later on. So off goes Mr. Cramer, and he starts grading his lot. Again, remember, owner-builder. He's doing it himself. He hires a grader. Owner-builder goes up. The neighbor calls up the architectural committee chair and says, you know what? I don't think his home is going to be in the 17-foot height restriction. It's looking like when he's putting the forms in, it looks like it's going to be a little higher. So the architectural chair comes out and talks to Mr. Cramer. Mr. Cramer, you understand, don't you? You understand that this house cannot be, yes, I understand. Off the architectural chair goes. Mr. Cramer's house is completed. The association does not go to court because they're, based upon all of this that they've done, they are relying on him to be within the height restrictions. How tall do you think his house was? 17.6? How many people think it was more?
More.
I think I've heard that case.
It was 26 feet above the control point of the lot. He missed it by 9 feet. So how many people here think the court ordered him to pay damages to the association and his neighbors? How many people here think the court ordered him to remove his house to the tune of, his own experts were used against him. They testified that it was going to cost $250,000 to regrade this, to move the house. They had to actually cut the house in half too, which is kind of funny. Cut the house in half, move it off the lot, regrade the lot, and put the house back on.
That's the one.
That's a conservative estimate, the latter. The court ordered him to regrade the lot. And in fact, I should have brought the pictures for you. I've been in touch with the manager for this association, and she sent me the pictures of the house up on the scaffolding. It's really quite beautiful. It's really astounding that all of this money has been spent on this home.
It's going to make 6 o'clock news sometime.
It's making the 6 o'clock news. So Darian's going to come back up. We have one more little thing to talk to you about before Bill Mann comes up and talks to you about hiring contractors. So you want to take over here?
So we're just going to talk real quick about, before Bill talks,